everyone.
Good evening, esteemed participants, and welcome to the training session for the fourth virtual International Mediation Competition 2024, proudly presented by Mediate Guru. I am Isha Shroff, your moderator for the today's enriching session. Today, we have the privilege of learning from one of the finest experts in the field of mediation, Ms. Ashu Dhiman. With her wealth of experience and profound insights, Ms. Dhiman will guide us through the intricacies of effective mediation techniques, equipping us for the success in the upcoming competition. Dr. Ashu Dhiman is currently working as an assistant professor at Vivekananda School of Law and Legal Studies, situated in New Delhi and affiliated to Guru Gobind Singh Indra Prasad University. Dr. Dhiman has her expertise in criminal laws, business laws, and family laws. She also has a very deep interest and a stake in alternative dispute resolution industry as the increasing scope of ADR is bringing speedy justice to the needy. Dr. Dhiman is also elected Chief Advisor at Mediate Guru's Global Advisory Board, where she regularly gives her valuable advice and consultation to the partners and associates in the firm and stay actively involved in the operation of the firm. Throughout today's session, Ms. Dhiman will delve into the core principles and strategies of mediation, providing us with practical tools and techniques to navigate the complexities of dispute resolutions, from active listening to creative problem solving. Each aspect of mediation will be explored in depth. So, without further ado, let's begin today's training session with Ms. Ashu Dhiman as our guide. Ms. Dhiman, the virtual floor is yours.
Errors. Sorry. Yeah. Good evening, everyone. So, all the best for your competition, first of all. And I'm Dr. Ashu Dhiman, and my introduction has been given by Isha. Thank you so much, Isha. So, today we are going to talk about mediation again. We have talked about it many a times with Mediate Guru, and I think many of the participants have attended this session with me. So, again, the point here want to know that how many of the participants have participated in mediation competitions earlier. I want to know that. Can you please raise your hands? How many of you have participated? None? I think my laptop is not responding well. Am I audible, Param?
Yes, you're.
Yeah. So till now, I have just seen one raised hand. That is some Munir who is raising his hand. That means there is only one person who has participated. So according to this, there are new students who have been participating this for the first time. So I request Mr. Param Namra to kindly help me in operating my PPT because it is not working from my end. So kindly share your screen if possible, and if not, then we can just go without that. Yeah, I think he's trying to do so. So till he does so, we can discuss about mediation. And before discussing about mediation, it is always very good to understand what a conflict is. So yes, the PPT may be in front of you, and I think everyone is able to see that. So it is fourth edition of Virtual International Mediation Competition 2024. And this mediation training workshop is not only about understanding the way how we mediate. It is not only the training about mediation, but we are also required to understand that to know what mediation is, we need to understand that what is the nature of dispute which we are handling. So can you please change the slide? So now we will come to know that how and what we are going to gain by going through this session. Can you please change the slide? Yeah. So it is very important to know that what ultimately we are going to get after this mediation session. Whatever we are learning, whatever lecture we are attending, we need to understand that ultimately what will be the consequences, what will be the original learning. So that is why we have mentioned certain outcomes for you, that after the successful completion of this session, you'll be able to understand conflict, because understanding conflict is the gist. Because if we will not be able to understand the conflict, then we definitely will not be able to apply the required mode of dispute resolution. So that is why we will be understanding conflict at first place. Then we'll understand that what are all the modes of dispute resolution, and which mode shall be applied in which nature of conflict. And then we are going to appreciate the concept and process of mediation, and that is the key of today's session. And then we are going to learn the effective ways to communicate during the mediation session, and to understand the role of the mediators, that how they can ensure a productive session and how they can prevent derailing. And we'll also talk about the roles of counsels, as students are always keen to know that what will be their role as counsel in the mediation session, because it is said that it is about the parties only. It is a party-centric approach. So parties are there face to face. Because if we talk about litigation system, so we'll find that in litigation we are being represented by a certain person who is a counsel advocate. So everything is upon the advocate, that how is he going to argue in the court and how he is going to present our case. So ultimately, the whole burden is onus is on the advocate. But in mediation, if we are saying that what is the role of counsel, so we need to understand that if we are coming, a client is coming into the mediation session with his counsel, and we are also saying that it is client-centric, then what is the role of counsel? So we are trying to understand that. And also I'll be putting light on the role of clients as well, that how clients are required to differentiate from the role of counsel. So what they are required to take with them. And ultimately we'll be discussing about the diplomats representing a negotiating while negotiating, the diplomats representing a country. So we can switch the slide. Yeah. So as I have said, that we are going to understand the conflict at first place. VIMC'17, yes, slides can be shared. That is not an issue. So the point is that understanding conflict is important before understanding the skills, or understanding that what mode of dispute resolution should be applied. So it is always good to study mediation with understanding or examining the nature of conflict. Conflict is a part of life. We all may have conflict in our life, and how it comes into picture. Because as we know that every individual is having different perspective. I do have different perspective. I may have different perspective on certain thing, and another person may have different, right? So the point here is that if it is about perspective, it may not always be same. It will be different. And if it is different, then definitely there will be differences on the point of view itself. And if there are differences, there is a possibility that people, obviously disagreements will bring disagreements, dissatisfaction and differences between the parties, and ultimately it may go to conflict or dispute. So that is why there is a requirement of understanding the nature of conflict. And conflicts may be of many kinds, right? It is, it depends upon the relation you are having with the other party. So we do have different kinds of relation. If we have family relation, it may be by blood, by adoption, or by marriage, right? So again, the nature of dispute changes. Even in the family setup itself, I have said that we have three kinds of relationships in a family setup. We do have relationship by marriage. So if we have relationship by marriage, that means there is a dispute between a husband and wife, right? So it may have different reasons. This dispute may have a different reason. The different nature of conflict it is, right? And if we talk about a dispute birth, right? So if there are certain people who are connected by blood, right? That means obviously blood relation arises out of birth. So the point here is that they may have different sort of dispute, different sort of differences, because different rights are there involved in that as well. So there may be the concerns related to property, right, or any other things like of such nature, which are related to the blood to the parties. And there is a possibility in family setup itself. I'm not just inclined towards talking about family only. I'm just giving an example that this is possible, that we are having different kind of relationship with the party, then the nature of dispute ultimately changes. So it depends upon nature, relationship, it depends upon the data, it depends upon many other things, that the nature of the conflict. So that is why it becomes necessary that how do we understand and determine the conflict. So again, it actually make us determine the way we put forth mediation. So can you please change the slide so that we can talk further? So this conflict triangle has been taken from Mediation Training Manual of India. You must be aware of the same, which has been created by Mediation and Conciliation Committee of Supreme Court of India. And it was on recommendation of Supreme Court itself. So it is providing us with three important things, and it is saying that we do have a conflict triangle where we are actually having three things, three P's which are required to be looked into. It is conflict is related to people, and there is a problem, and then there is a process. So why people? Because always whenever there is a dispute, I have said that there is always a difference of perception, point of view between the people. Or even if we say there is a cultural gap, there is a possibility that if you are a sibling, you are siblings, then also there is a possibility of different point of view. So what people, the point people comes with, people may have a past history, people may have different values, meanings, they have different relationships, emotions, behaviors, abilities, and personalities. So these are the points which actually come up with the conflict, right? So these points may be related to people, which actually give birth to problems. And those problems may be with respect to facts, positions, issues, consequences of events, the perception people are having, their interests, needs, and the solutions, and the consequences of the possible outcome. So these people are having certain issues, and then they are coming up with certain problems on that. And then lastly, how they are responding to it, how people communicate. That is the process, that how they communicate issues and feelings, and how structure, systems, and procedures, and the norms about how to behave in a conflict, decision making, and their jobs, their roles, which are they are playing during that process. So that means we can see that there are triple P, three P's are there, which are involving people, problem, and process in a conflict triangle. So we are required to deal with all these things. We can switch the slide so that we can understand the conflict triangle number 2. So this is conflict triangle. If we put the mediation thing in that conflict triangle number 1, which we have discussed now. So what mediation will do, it is going to support the people and solve the problem and control the process. So it is something which is going to ultimately give the solution to the problem. So can you please switch the slide? So this is how we understand that there are different nature of dispute, different kinds of dispute, and those different kinds of disputes or conflict actually vary from relationship, value, data, structure, everything. So we need to understand that what kind of dispute. I'm not going to take all kinds of disputes here. I just want to put forth the example so that you can look into the sources of that kind of dispute, because ultimately as I have started, I have just given an example of dispute which comes up in family itself, right? So if it is about relationship, let's say, so I have told you that there are three kinds of relationship, and out of those, there are conflicts, there is dispute. So what will be the sources? You see, if we talk about value, the sources of dispute may be different. If we talk about relationship, the sources and characteristics of that dispute must be different, right? If we talk about relationship, because it is between two people, there is a reason of dispute, that is poor communication, the repetitive negative behavior between the people. Let's take example of spouses. So there is a possibility that one spouse is repetitively giving negative behavior, and the other is positive, but still at one point of time he will become negative, right? So that's how it comes up. Then there may be misperceptions, there may be stereotypes. So always there are strategies to resolve. If we will find out that what is the kind of dispute, we'll find out the sources. And if we'll find out the sources of that dispute, we will have better strategies for resolution. Like we will try to clarify perception. How are we going to clarify perception? We will try to improve communication, because they do have communication gap. So we will try to improve the communication between the parties, and also let them learn from past and think about what they want in future, right? So this is how it works. We have value based. Please switch the slide. They just will check what kind of disputes are there. So value based dispute, again, there are different characteristics and strategies to resolve such kind of disputes. And then I think I'm audible. Param, can you please change the slide for me? Thank you. Then structural disputes are there, where data disputes, if there is lack of information, misinformation, and benign interpretation, then there are different strategies on resolving the dispute. So the point here is that if we talk about litigation, we are somewhere in a competitive approach with respect to, because it is again a right-based model. Right, so we are actually looking about our rights, because the Constitution has provided us the rights. That is why we are looking for the rights, right? And we are trying to, even if it is a fundamental right or a legal right, we just believe that we are required to get them enforced, right? So that's how it is a right-based model. But if we talk about mediation or even any other alternative dispute resolution mechanism, it is not about rights. It is about interest. Right, can you please switch the slide so that we can proceed further? I hope I'm audible. I'm so sorry that I'm disturbing you again and again. Yeah, please go to the modes of dispute resolution. So again, I have talked about knowing the nature of dispute. So I believe all the participants will be able to understand that it is important to note that how a dispute occurs. What is the nature of dispute? It is always important to understand the conflict. So I believe all the students are now able to understand that how we can find out the sources and characteristics of a dispute, and how we can put certain specific strategies after understanding the nature of dispute while doing so, right? While putting any alternative dispute measure in it. Then comes modes of dispute resolution. So what are the modes of dispute resolution? I have just divided them into three parts. One is unilateral, another is bilateral, and third is assistance by third party, or there is third party involvement, right? The point here is that if I have mentioned that there are three kinds of dispute resolution, what are they? I have divided them. You must be thinking that there is litigation and there is ADR. Yes, that is true. But the point is that how they are being divided. Usually what happens if we talk about unilateral one. So in unilateral, as the name itself suggests, that there is only one party involved. Let's say if I am having a difference of opinion or point of view is different from the other party. So what I can do, I can just avoid the dispute by forgiving, right? So that is called avoidance. So we are not actually getting into the dispute. We are just forgiving the other party. We are just letting that party do whatever they want to do. That means we have actually given up over our interest. We are not looking for our interest at all. We have avoided looking into our interest or right, right? And secondly, we do have another method, that is bilateral mode. So in bilateral, as the name itself suggests, again, that there are two parties involved. So again, if we talk about dispute, because if we say unilaterally, we cannot say that it is a dispute, because we have not raised the dispute at all. We have not discussed the dispute at all, because we have resolved it unilaterally without saying anything to the other party. We avoided it. But if we talk about bilateral mode, so you see bilaterally, there are two parties involved in it, right? If one party is having dispute with the another party, that means there are differences. So what those two parties can do, they can sit together and try to talk or communicate upon that dispute, discuss it and try to resolve it. And that method is called negotiation. So now there are only two parties involved. They are the parties to dispute, and they can sit and find out the reasons, find out the issues which are there for the dispute, and then they can resolve it. Third one is really important, where there is an importance of third party which is involved in helping us in resolving our dispute. Third one is assistance by third party. Now, I again bifurcate the same. If we talk about assistance of third party, we find that there is one kind of dispute, that is adjudication, right? Dispute resolution, that is adjudication. And another one is while we are taking the assistance of third party, the help of third party. So if we talk about adjudication model, so in adjudication, what happens? There is a neutral third party who is going to resolve our dispute when we are going to put forth our issues and our evidences, or we can say he is going to decide on the basis of merit. And that is adjudication method. And under that head, again, certain bifurcation comes up. That is when someone is going to decide, it is court, maybe litigation method, we can say as well, litigation method also, plus arbitration. Arbitration is also called such a method wherein one party, one neutral person is going to appreciate the evidences provided by the parties and going to decide for the parties, going to adjudicate for the parties for on the basis of the merits, on the basis of the evidences provided by the parties. Although both are different in terms of applying the procedure, because for litigation, the procedure is a bit, lengthy. But in case of arbitration, the procedure is not that lengthy and formal. It is an informal method. And in adjudication or in litigation, specifically, in litigation, there is a person, the neutral person is not been chosen by the parties. But in case of arbitration, there is a neutral party who the parties to dispute themselves choose as per Arbitration and Conciliation Act, right? And then if we talk about the other hand, that is assistance of third party, wherein there are these dispute resolution mechanisms like mediation, right? Conciliation, early neutral evaluation, there is lok adalat, right? Mediation, conciliation, and then further there are many other where the other party is the third neutral party is there, but it is not going to adjudicate. It is just going to assist us, help us in finding out the solution to the dispute, resolution to the dispute. So that's how we understand the different modes of dispute resolution. Please switch the slide. Now, after understanding the dispute, what is dispute, what is the conflict, and what are the sources of a kind of conflict, because there may be a different kind, different nature of conflict. We understood that there are different mode of conflict resolution mechanism. We call it appropriate dispute resolution when it comes to ADR. And then concept of mediation is very important to understand afterwards, because right now we are not talking about any other alternative dispute resolution mechanism. We are just specified to discuss about concept of mediation. So as you all have gone through when looking into the problem that has been provided by the mediate guru or the organizers of any event, so you might have seen that they have given certain specific things to you. So that means you are clear about the term mediation. So mediation is a voluntary, party-centered, and structured negotiation process. So it is voluntary in nature. That means parties do have their own wish, their own will to come to the mediation table in order to get the dispute resolved by the person, by a third neutral party. And it is totally party centered. When I say party centered, in your opening statement, you are required to tell the parties as a mediator that it is a voluntary process, right? So you are required to tell them, right? Just give me a second. I'm so sorry for this interruption. Yeah, so we were talking about mediation, as I have told you that it is a voluntary process and it is party-centered. And I have told you that how it is party-centered because it is voluntarily being done by the parties, and parties are the decision maker in the process. Ultimately, it will be upon the parties to decide whether they are going for settlement or not, or whether they believe that the disputes are resolved or not. And then it is structured negotiation process. Why we are calling it to be structured negotiation process? Because the parties are only involved and they are directly talking to each other. Mediator is acting as a facilitator only. He is letting the parties to talk to each other, to communicate. And where a third neutral party assists the parties, that means the mediator is just assisting the parties in amicably resolving their dispute by using specialized communication and negotiation techniques. So he actually makes you mediator. What is the job of mediator? To when I'm saying that it is party centered, that doesn't mean that mediator doesn't have any role to play. Mediator has a crucial role to play in mediation because he is going to apply the communication skills he has, as well as he is going to understand what parties want to say, right? And in certain situations, mediators also play the role of evaluator, wherein they provide certain solutions to the problem. They can suggest certain solutions to the problem. So yes, they do apply certain techniques, certain processes there, and they help the parties to come to an amicable resolution. And in mediation, the parties retain the right to decide for themselves whether to settle a dispute and the terms of any settlement. So even though the mediator facilitates the communication and negotiations, the parties always retain the control over the outcome of the dispute. So parties always have the control. That is why it is party-centered, and parties' control over the outcome of dispute is important to note here. We can switch the slide to move further. So it comes about the process of mediation, as we have understood that what is the basic idea of mediation, what is the concept of mediation, and it is dynamic in nature. The process is dynamic in nature because it involves various stages, right? So what happens? The mediator assists the parties to negotiate the settlement so that they can resolve their dispute. And for doing so, definitely they need to have certain structured manner, right? So there can be said to be 4 functional stages of mediation. One is introduction and opening statement. Another is joint session, then separate session and closing. I think all the participants who are, who have just entered in this arena of mediation, they will understand that these 4 stages are really, really, really important. None of the stage is such that they can just skip their role. In every stage, they are required to have a role to play, a different role, I must say, because they will remain mediators. And it is not for mediators only, it is for the clients and counsel as well, that it is important that if you are there for, let's say, for 1 hour, you are in mediation room for 1 hour, so you are going to pass through all these stages. And when the stage switches, the way you communicate switches. For example, if we talk about introduction and opening statement. So talking about mediator for introduction and opening statement, what happens during the mediation process? The mediator breaks the ice. If he breaks the ice, and by starting it with the introduction that I'm so and so person and I'm here to mediate, right? And he may tell his experiences or whatsoever is involved with respect to his introduction. But the point is here that there is a time limitation provided to that person, to the mediator and every person involved in the mediation process. And I think all the participants have gone through the time limitations provided, that this party is having this much time, or this particular session or this particular stage requires this much time for mediator, and etc. etc. Everything has been given by the mediate guru or the organizer of the event. So after giving his introduction, he is required to ask the parties to introduce themselves, and then the opening statement. So again, it switches. Now he is required to give the opening statement with respect to mediation. He need to tell the parties that what mediation is. You are required to give the process of mediation as well. What mediation is, what is the process, and also you are required to give certain ground rules during the opening statement, as well as you are required to tell that how mediation is important to resolve their dispute over litigation, how they can in a better manner they can resolve their dispute. And obviously it is faster method if we compare it to the litigation method. So you are required to tell them. Also, you're required to tell them that how confidential the process is going to be. So everything the mediator is required to tell. And if we talk about the opening statements by the other parties, they are required to tell what are the problems, what are the issues they are facing with respect to that dispute which has occurred, so that agendas can be settled, right? And then comes the joint session. Now, in joint session, it is very important for mediators to note that if one party is telling what they are going through during the dispute, what are their problems, what are their issues, do not lose the control over the process of mediation. What usually participants do, they listen to the parties and they let them speak. They keep on speaking, the parties keep on speaking, and sometimes the other party doesn't get the time to speak. So that is why time management is a teamwork, because if there are 6 people involved in the mediation competition, then they are required to look into the time management as well. So whatever time has been prescribed for you as a team, right? So you need to follow that. That is important. All the judges are noting down your time. So that is very important. And you might have gone through the marking criteria given by the organizers. So definitely look for the time and the points on which you are being marked. For every session, for every stage, there is a separate way of marking. So you need to check that what are all particular requirements are there for the sections, right? So in joint session, you are going to tell the facts of the case, as well as you are going to like how it is working. Like client is telling that this and this happened and these are my issues. So what counsel has to do now? Counsel is required to look into the legal technicalities of it, and client is required to stick to the factual matrix of the problem. So that's how they can collaborate, and they can better make the mediator understand the problem they are having. And now, what is mediator required to do? After listening to the parties, they are required to reiterate what the parties have said, so that the parties can understand that mediator was listening. Because again, it is crucial that to understand that non-verbal communication has much role to play in mediation. But that doesn't mean that you will not speak as a mediator. You have to speak, and you have to make them understand that you are required to be empathetic, that you have understood the problem they have shared with you. And also sometimes the parties to dispute actually comes up with an emotional outburst, and it may be of many kinds. It may be related to the dispute itself. For example, if it is a family related dispute, there is a possibility you are dealing with spouses, and there's a possibility that spouses start either there may be emotional outburst, or there may be negative emotional outbursts as well, right? So at that point of time, how you are going to handle the situation, you are required to get into it. You are required to be empathetic towards them and let them understand that you have understood that what is their situation, right? And you are required to handle that. And there's a possibility that they are out of that particular thing, because today itself I have judged a competition, and I have found that there was one person, there was another party, he was not feeling good about the good amount of time used by the another party while discussing or telling his problem to the mediator, right? So he lost his control, and he started saying on the screen itself that it should be noted. He actually opened like this, that it should be noted that they have exceeded the time limit, right? At this point of time, they have actually had emotional outbursts, and that is not with respect to the facts of the dispute. That was not related to the dispute. But since he was in the competition, so he actually got the insecurity that they have actually taken much of our time, and we will not get time to speak. So that is why he behaved like that. But the mediator did not say anything. So that was the point. But in competition, both kind of things may happen. So you are required to handle the situation very amicably and calmly. So you are required to tell them that yes, these things are being noted by the judges, right? So we are not required to talk about these things in the mediation session. Let us stick to the dispute itself. And then the point that is third stage, that is separate session, that is caucus, we call it caucus. So what is caucus? Where one party, now there is a possibility of caucus, and then cross caucus may be there. You can go with, I don't know if Mediate Guru is allowing, but there is a possibility that we can go for a caucus with our, both the councils can go for a caucus, both the clients can go for caucus, and there is a possibility of caucus between any of the members of this, the people who are there on the mediation table. So it is again depending upon how the organizers are dealing with it. And lastly, there is again, I'm so sorry, I have skipped one thing. When we are talking about separate session, and this is always a question by the students, that how separate session, what is the right time to take a caucus? What is the right time to take separate session? So the point here is that you can take separate session at any time, right? For example, if you want to tell something to the mediator, right, which you do not want to disclose in front of the disputing party, the other party. So what you can do, you can ask the mediator before even setting the agendas, that you are required to take a caucus. You want to tell some things, some important things before taking the agendas as well. And even if you are in an impasse while in joint session, you can also take a caucus. And during caucus, you are required to tell, as a mediator, you are required to find out. Again, you are going to ask the open-ended question so that the parties give you more and more information. And in a competition, it is important that you take out the information which they have received later on, that is confidential information. And it is again your skill to make the parties to come up with the solution. And then again, we can have, after separate session, we are required to come back to the conference session, that is joint session, and we can discuss further, and we can set the agendas. And if the agendas have already been set, we have left from at some impasse or deadlock, then we can restart. We can try to restart. As a mediator, it is again our skill to make the parties restart, because they were in an impasse, they went to a caucus, and then how they will make a comeback. So that again, it's our job as a mediator to facilitate the discussion, so that parties may communicate with each other, because our ultimate goal is to provide the parties the solution, the amicable resolution to the problem. And lastly, the closing. The parties are going to give the closing statements, and there may or may not be a settlement agreement. So it is not mandatory that if we have entered into a mediation process, we are supposed to give this settlement agreement. If there is no settlement between the parties, there is no point of settlement agreement. So, but while closing, as a mediator, you are required to discuss what all you have discussed throughout the session, what were the agendas, and what were the solutions, if any, what were the solutions proposed by you, and what were the solutions you came up finally in the end, how the parties have resolved their dispute, etc. You are required to tell in the closing statement. Can we proceed further? Param, can you please change the slide? Thank you so much. So this is how we can work while we are into the mediation session. So after introduction, we as a mediator, even if we are not a mediator in a session, or we are the parties to dispute, please keep it in mind that we all are required to understand the problem. Since even mediator is required to understand the problem, because he is the one who is facilitating the communication, and at times he is required to play the role of an evaluator. So yes, all of you are required to understand the problem and the deeper understanding of interest and needs of the parties. This is not only for mediator. This is actually said to be for mediator only. But as negotiating parties, as good negotiators, we are required to understand that what our interests are and what other parties' interests are. Again, I'm saying that it is an interest-based model. There is nothing to do with rights. So if you will be able to understand your strengths and weaknesses and the other party's strengths and weaknesses, you'll be able to put forth a better solution to the problem, right? So that is why there is a requirement of deeper understanding of interest and needs of the parties. And then you are required to define the problem. As a mediator, you can define the problems, you can help them in creating options and evaluating options, and lastly, you can come on settlement or non-settlement. If we talk about a competition, it is not important to come to a solution, but the process, the session that has taken place must be such that you have actually given all the skills, you have put all the skill forth in front of the judges with respect to mediation. That is more important. You have tried to come to a solution. So then lastly, if you do not come to settlement or solution of the problem, you can end up saying that we tried to do, and we can also choose certain other date to sit together and talk to each other regarding this problem. So we can solve it later on. But yes, we need to discuss that. Can we switch the slide? I want to know if all the participants are listening to me. Please raise your hands who all are listening. Okay, some of the hands are raised. Right. So the students who are listening to me, please, you can ask the questions after the session, because we are just going to end up. There are 3 or 4 more slides, then we are going to end up. So please be ready with your questions with respect to mediation. Yes, so we have discussed the role of mediator. Right. When I have just started with the role of mediator, and I have told you that there can be 2 kinds of roles of mediator, that he can facilitate the process and he can also evaluate the case, right? So while facilitating, because before AFCON's infrastructures case, it was like that the mediator was having a facilitative role only, and he is not going to take any active part in providing the solutions or giving certain suggestions that they get solutions or evaluate the case as such. There was no role of mediator as such in this case. But afterwards, now what has happened, that after AFCON's infrastructures case, the court has said that mediation and conciliation, because earlier the process wherein the third party, the neutral evaluator was a neutral person was required to evaluate, that process was called to be conciliation. But now the court has said that mediation and conciliation must be used as synonyms, right? So that is important to note here. So that means the role of mediator may be of facilitator as well as of evaluator. Can you please switch the slide? So in his facilitative role, there are good functions to do. Firstly, they can create a conducive environment for the mediation process, and then explaining the process and its ground rules, facilitating communication between the parties, identifying the obstacles to communication between the parties and removing them, and gathering information about the dispute. And they can identify the underlying interest. These things we have already talked about. They are required to manage the interactions between the parties. They are required to maintain control over the process, assisting the parties and motivating the parties to agree on mutually acceptable solution or settlement. Please switch the slide for evaluative one. Yeah, for evaluative role, what they are required to assess what is the problem, and they can also help them in guiding that how they can they can go through reality testing. They can tell them that how they can look into the future, right? Because again, I'm saying that it is a interest-based model, so future of parties, and they can also provide them a solution that these can be the solution to your problem. But again, they are not having adjudicative role, so that is why it is upon the parties to understand or to apply that particular thing, the option generations which have been provided by the mediator. So it is again upon the parties, because it is party-centric approach. We may switch the slide, please. So lastly, we are supposed to discuss the role division of client and counsel, and I have already told you that there is a difference of role of client and counsel. Client is required to look into the factual metrics of the case, and the counsel is specifically required to look into the legal technicalities. And when you are into a competition, you are not required to, because it is a teamwork, right? So you must not interrupt each other. You are required, if the client has ended his statement, then only counsel should start. So do not interrupt each other. And if you want to communicate, silently communicate with each other. Do not whisper, right? And if you can try the written communication thing. You can keep a page, paper or pen with you, and you can just mention whatever you want to tell to your client or counsel. And if you are on virtual mode, then you just can write it in a chat box, personal chat box. You can do that as well. So this is very important to note, that non-verbal communication is not only important for mediator, but also important for client and counsel, because they are also communicating as a team with each other. So that is why they are required to have such teamwork, that silent communication work between them. Right? We can change the slide now. Yeah, and this is very important part, that there are always two types of communication. One is verbal and another is non-verbal communication. So if we talk about verbal communication, it is very easy, as we are talking to each other. And in during verbal communication, it is possible, because we have certain such sentence formation, that if something exclamatory is coming out, then it is clear the way, the tone we are using, or the body language we are having. If we are asking a question, there are certain words which determine that this is the question, right? So things are much clearer in verbal communication. But when we talk about non-verbal communication, in mediation, non-verbal communication has a much role to play. You are required to be active listener. You are required to listen with empathy. Your body language must be such that the other party, the person who is telling his problem to you, who is sharing his problem, understands that yes, you are listening to him. And again, lastly, you should ask right question. What does it mean by asking right questions? How do we find out that we are asking right questions, right? So we need to ask open-ended question, right? So if I want to know what you have eaten today, right? So what should I ask? I should ask you what you have eaten today, right? Instead of asking what you have had in your breakfast, right? So he's going to give me only information with respect to breakfast. If I'll ask that what you have eaten today, he is going to give me the description of whole day, that he has eaten this in breakfast, this in lunch, and this in dinner, right? So that's how we actually enhance the area of communication, by asking right question. There must be open-ended question. They must not be answered through yes or no only. It must be such that the parties give you more information about what the question you have asked. So it must be open-ended always, right? And lastly, we can switch the slide. Yeah. If you are representing a country as a diplomat, so there are certain points to keep in mind. Otherwise, everything is similar as we have discussed. So first of all, you are required to prepare. You are required to do R&D about geopolitical context. You are required to be aware of all the things with respect to that country through which we are actually representing the other country and dealing with another country. So objective setting and strategy must be there. You must have open communication and transparency. And then legal expertise is also important, because you must have compliance with international laws, right, and case studies, etc. And lastly, you must understand the cultural sensitivity and emotional intelligence, because again, it actually is called cross-cultural mediation, where we need to understand that the other party or other country belongs to such a cultural background that there may be certain things which are normal for us, they may arise culturally sensitive. So that is why we need to find out that whether such cultural sensitive or emotional intelligence are existing or not. We need to understand that, and then only we can apply better negotiation as well as mediation skills during such sessions. So that is all from my side. If there is any question, because many of the students have taken part in the mediation competitions earlier, and they can ask questions from their past experience if they have faced any issues. And if the students are new, they can also ask questions. There is no question?
So there's a question.
Yeah. What's the question? What kind of relationship would be between company partners? I can't see that. Here it is. Company partners, what be the best way to resolve it through a mediation session? So, yeah, it is a professional relationship, and the reason for you are required to find out the reason between reason of the conflict between these people, right? So it is important to, it is crucial to understand the relationship, as I have told you earlier, that if there are partners, right? So that means they are having similar rights, right? So they are having similar rights, so they are having issues with respect to the partnership only, right? So that means you are required to look into their interests together, right? And you are required to apply the strategies wherein they come up with the solution of the problem equally, because they are partners in the company, right? So that's how you can use such strategy. Another question? Okay, that's it. Any other question? No questions at all. Fine. So all the best to everyone. Yes, ma'am. What do you want to say?
Thank you, Dr. Dhiman, for an enlightening and inspiring session. Participants, we hope you found today's training session valuable as you prepare for the 4th virtual international mediation competition. Wishing you all the very best in your endeavors, and we look forward to seeing you at the competitions. Thank you, ma'am.
Thank you so much. Thank you, everyone.
And participants, don't forget to join us tomorrow at the same time for the second expert session by Dr. Sasha Mata.
Thank you.
Thank you.